Good morning, ladies and gentlemen. Thank you for joining me today. I'm Attorney General Eric Schneiderman, and we're here today to make an important announcement about Internet access and fraud in connection with Internet access in the state of New York. I'm proud to be here with some of the tenacious attorneys from my office that have worked very hard on this investigation. Kathleen McGee, the Chief of our Bureau of Internet and Technology, Simon Brandler, a Senior Advisor and Special Counsel in my office, and Assistant Attorney General Muhir Shirsagar. Muhir. I'm also joined by Manisha Sheth, the Executive Deputy Attorney General for Economic Justice. And I want to acknowledge Tim Wu, who is here, who was with our office in the early stages of this investigation, was instrumental in getting it off the ground and helping us deal with some of the legal and technical complexities that make this a really an unprecedented lawsuit. The rest of the team, some of them here also, I thank them for their incredibly difficult work and the long hours spent trying to track down the facts and put together the complaint which we're filing today. Ladies and gentlemen, it is no secret that for the overwhelming majority of New Yorkers and Americans, the reliable Internet access is not a luxury. It is a necessity. Millions of New York families rely on dependable Internet service so they can work from home, stream videos, stay in contact with family members, connect to their communities. Many New York families are willing to pay a premium to ensure that they get the reliable service they need. For years, Time Warner Cable, now in the process of rebranding itself as Spectrum in some parts of the state, promised those families, quote, blazing fast and, quote, super reliable Internet service. But after a 16-month investigation, we found that the company conducted a deliberate scheme to defraud and mislead New Yorkers by promising Internet service the company knew it could not deliver. Today, my office filed a lawsuit against Charter Communications, which acquired Time Warner Cable, for years of alleged fraud against its subscribers. As the state's largest supplier of Internet service, Spectrum Time Warner is a dominant force in New York's Internet industry. The company earns more than $1 billion in revenue a year by selling residential Internet access to about 2.5 million New York households statewide. That's more than 1 in 3 of all New Yorkers who pay for Internet access. My office looked into thousands of complaints from Spectrum Time Warner subscribers who said they weren't getting the Internet service they were paying for. And I have a message for those complainants and for all New Yorkers. The allegations in today's lawsuit confirm what many of you have long suspected. Spectrum Time Warner has been ripping you off. Time Warner Cable built its multi-million-dollar ad campaigns around the promise of fast, reliable Internet service. But the reality is that the Internet service was neither fast nor reliable. A careful analysis of internal corporate communications and tests of subscriber Internet speeds showed that Spectrum Time Warner subscribers were getting dramatically shortchanged. Despite labeling its high-speed plans with names like Turbo and Extreme, our complaint quotes from internal corporate emails that show that company executives knew that their Internet service was often far slower than promised, and that many subscribers would never experience the speeds they were paying for. My office also looked at the results of Internet speed tests from tens of thousands of New York subscribers who paid for the company's top 3 speed plans. The results for some of these plans are on the charts here. But the 100, 200, and 300 megabit per second plans, we looked at a lot of actual tests for real customers, and the test results showed that Spectrum Time Warner consistently failed to fulfill its promises to subscribers. Take, for example, subscribers in the top speed plan, who each paid as much as $110 a month for what they thought was 300 megabits per second speed. What did they actually get? On average, we allege that they got just 85 megabits per second. That's 70% slower than what they were paying for. Even subscribers in the more modest 100 megabit plan were barely getting half the speed they paid for. Our results are based on multiple speed tests, including tests by the federal government, and even Spectrum Time Warner's own internal tests. It is a consistent story of bad performance and a long-term business plan built on deceit. Furthermore, despite promising subscribers the same super-fast speeds provided through their wired connections through wireless service, Spectrum Time Warner knew its speeds were even slower on Wi-Fi, which is how more than 90% of the company's subscribers access the internet. Spectrum Time Warner's engineers actually warned its business executives that the nature of Wi-Fi makes it virtually impossible to achieve wired speeds wirelessly. But Spectrum Time Warner concealed these essential facts from its subscribers. We allege that wireless subscribers in the top speed plan got speeds that were 85% slower than what they paid for on average. That's like paying for a car with a 300 horsepower engine, only to find once you've driven off the lot that you're puttering around with just 42 horsepower under the hood. As we allege in our complaints, these shockingly slow speeds are the result of a calculated corporate strategy. Internal emails show that Spectrum Time Warner executives repeatedly refused to spend money on its networks in order to boost profits, knowing that this failure to spend money would overload those networks, ensuring the delivery of subpar service. Internal emails also show that Spectrum Time Warner executives knew that the hardware they were leasing to subscribers was technologically incapable of delivering the speeds those subscribers were paying for. As one executive put it, quote, "We are going to experience a mismatch between what we sell the customer and what they actually measure on their laptop, tablet, etc." For example, the company's own engineers warned as far back as 2013 that the outdated modems that Spectrum Time Warner had given its subscribers simply could not provide internet as fast as they had promised. Yet the company had the audacity to charge subscribers $10 a month to lease those subpar modems, knowing they could not deliver the promised speeds. Those fees add up. Between May 2012 and February 2016, New York subscribers paid Spectrum Time Warner $600 million in modem lease fees alone. It was only a matter of time, ladies and gentlemen, before some subscribers started to catch on. And they did, and the complaints started to flow. Now, the company could have solved some of these problems by simply upgrading subscribers' hardware, the modems and routers that they provided to subscribers. Giving subscribers faster modems and routers could have helped the company live up to its promises, and indeed, that's a solution that was suggested by the company's engineers. But they were overruled by higher-ups who explicitly said the solution would be too costly. At the same time, Spectrum Time Warner was aggressively and deceptively pushing more and more speed at higher and higher prices to its subscribers as the purported solution to the service delivery issues caused by Spectrum Time Warner's own malfeasance. One of the company's own customer service reps objected to giving subscribers such a hard sell. The customer service rep said, quote, "This is a hustler's job. We're trying to out-hustle everyone else, trying to make the most money we can and not doing the right thing. By operating like this, customers laugh at our integrity as a company." Based on the company's consistently terrible customer service ratings, it's fair to say that this rep was onto something. So, as alleged, despite earning more than $1 billion a year from New York Internet subscribers, the company refused to make the necessary investments to actually provide subscribers with the service they'd paid for. Furthermore, our complaint alleges that it wasn't only subscribers that were misled by Spectrum Time Warner. According to the complaint, the company manipulated the results of an FCC speed test to hide from federal regulators that they failed to deliver promised speeds. The company used a strategy called over-provisioning to game the FCC's report of subscribers' average speeds. Basically, over-provisioning hikes speed scores from underused service areas to make up for slower scores from more congested areas that really reflected the actual experience of the overwhelming majority of customers. In internal emails, company executives talk openly about using this strategy to undercut the FCC report. They even plan to use the tainted results in future marketing efforts to show how they, quote, "deliver more than promised speeds," close quote. And they fretted about how their deceptive practices were exposed by what the FCC referred to as the consistent speed test, which measures the minimum speed 80% of subscribers get 80% of the time, a test that was much harder to gain. The company's own engineers did not think too highly of over-provisioning, which only hid but did not fix any of the speed problems. A 2013 presentation by engineers called this method, quote, "putting lipstick on a pig." Ladies and gentlemen, for years, Spectrum Time Warner has been promising one thing and delivering another. It's important to know that the allegations in our complaint concern an ongoing deception. The name of the company may have changed from Time Warner to Spectrum, but the company has not changed its pattern of providing slower speeds than advertised. The company's motto might as well be, "New day, same fraud." Today's action seeks to bring much-needed relief to millions of New Yorkers that have been getting ripped off by Spectrum Time Warner for far too long. My office is committed to standing up for all New Yorkers to make sure everyone plays by the same set of rules and everyone gets what they pay for. Thank you for joining us today, and now Amy Spitalnik will moderate the Q&A. If you'd identify yourself.
So, will people get reimbursed in this lawsuit, customers?
Our prayer for relief seeks a full accounting of all the damages, and we are seeking reimbursement for customers who were ripped off. That's
As of 2012?
the relevant period for our investigation was January 2012 to the present.
Hi, Peter Haskell with CBS. Has the company claims it has since upgraded, so do you know anything about that, and what else do you seek besides the refunds of some sort?
Well, we're also seeking injunctive relief to have them fulfill their promises going forward. We have seen no indication of any significant changes, but if the company acknowledges there were problems and said they fixed them, then they essentially are acknowledging that they owe people money going back to 2012 when the problems that they just fixed, if they're admitting they had problems and they fixed them, they're sort of admitting they owe people money. So I'll be curious to see their specifics or their statement.
From WNYC. New York has a public service commission that regulates internet service. Is this something that they just missed? Do they not have jurisdiction in this area?
This is something that our office has been pursuing. Obviously, we're in touch with our colleagues in government, but this is an investigation we conducted independently.
Bobby and then
Hey, Bobby Guzman from Spectrum News.
Not getting back there anytime soon, am I?
I may not be able to go back to work. You mentioned that it went to top levels. Like specifically, are we talking about the CEO, top executives, and also with the internal emails? Were those subpoenaed, or how are you guys able to get that so far?
We identify specific emails and some particular executives. We have obviously the complaint only makes the point through samples of emails. We have a lot of emails, and this was obtained through subpoenas, and again, we got a lot of information from customers. So it was a combination of internal documents that we received and information we obtained from customers.
Scott Pringle, NBC News Radio. A couple of questions. You mentioned some numbers earlier. Do you have a rough idea of the percentage of all of New York State that could be affected, or a rough number?
Well, as I noted, they're providing 1 in 3 New Yorkers who pay for internet access with their internet service. So this is a huge portion of our state, and there are parts of the state where customers really have no other option at all. So they were either a quasi-monopoly or a monopoly and took advantage of that leverage.
And I'm sorry, just following up on what Peter was saying. You mentioned earlier, though, that it would almost be impossible to provide all the speed to that many people because it would overload the system.
Oh, well, no, in fact, and we make this point in more detail in the complaint, there were several different ways in which Time Warner Cable could have done the right thing. It could have replaced modems that they acknowledged were outdated and could not possibly deliver the proper speeds. They could have replaced the wireless routers that their own engineers said this will never deliver the wireless service that the customers are being promised. And they could have improved their network. All subscribers are in a service group. And if you have too many people in a service group using the internet too much of the time, either they're not going to get the speeds promised, or you have to add additional bandwidth to that service group, more channels, or break it up into smaller service groups. There were things they could do, but as set forth in our complaint, when engineers raised those possibilities, they were repeatedly told this would cost too much.
Do you have any sense as to how large a pool of money you look for to refund customers, and any idea how many customers might get back?
Well, we are part of what we're seeking is a full accounting because we want to understand exactly how many customers were charged how much for what services and what services were promised them. But again, they were charging more than $1 billion per year, so we're talking about a lot of money.
Is that what you're looking for?
We're looking for customers to be made whole.
Is it even possible to know who has experienced those slower speeds and really document it and specifically tailor some kind of remedy for those customers?
Sure, because there were 3 different tests, and this is all set forth in the complaint, 3 different systems for testing, and there were tens of thousands of tests that give us a lot of information about what the actual speeds were. I mean, this is something that we actually, through the great work of our research team and Tim's work, we were able to set up a testing tool on our own website, on the OAG website, and customers use that to test their internet speeds.
Is some of this, though, couldn't the company defend it as branding and marketing? I mean, Starbucks calls a small coffee a grande. So turbo speed, lightning speed, couldn't they easily say, you know, this is faster than it used to be? It's you who are saying it's not faster.
No, actually, because they didn't just call it turbo speed. They promised speeds of 100 megabits, 200 megabits, 300 megabits. Those are measurable speeds. It wasn't. It's like as though Starbucks said, "This is 18 ounces," and it's actually 6 ounces. That's a better analogy.
So what was it, so if it was not just about luring customers with better speeds, how much money were they reportedly saving by not giving people the speeds as advertised?
I mean, we don't know precisely, but their own internal emails reflect a concern that this would cost them hundreds of millions of dollars to upgrade just the hardware, and that we have repeated statements, some of which are in the complaint, some of which are in other emails which we haven't included in the complaint, making clear that there were statements such as, we don't have that kind of capital, things like that were said by the executives in response to the engineers' pleas that we need to do better in terms of our network and our hardware, otherwise we're never going to be able to deliver the speeds we're promising our subscribers.
Attorney General, do you have Time Warner cable at home?
I do.
Did you find some slower speeds?
Well, this is an interesting thing. Part of what they took advantage of is that each of us when we experience slowness or we experience problems with our internet, we tend to think, maybe it's just me, it's my router, there's too many things going on in the apartment next door or something like that. I'm going to go down to the store and get another modem, not knowing that everyone else in my subscriber group was going through the exact same thing at the same time. So they use the fact that we're all fragmented in our use of the internet, and most people tend to think that there's something that they can do in their own apartment to speed it up. When you call them up, they'll say, well, turn it off and start it up again, and maybe that'll help. And it was an ongoing conscious plan of deception at the corporate level.
CNBC, Chris Falco, are they still advertising this? Are they still, promoting this?
Well, the ads change over time, but they have not backed away, as far as I know, from the claims that they're delivering to 100, 200, and 300 megabit service when we know they're not.
Anything else on this topic? Sure.
Yes, Alfredo Costa from Telemundo. Have you considered about to investigate other providers?
We are taking a look at all broadband providers in the state of New York, and those investigations are ongoing. This is the largest provider, so we've been pursuing this the most aggressively, but we're looking at everyone.
Different topic.
Yeah, let's move on to other topics.
How concerned are you that problems like this might get worse if net neutrality rules are eliminated, which might happen in the Trump administration? And secondly, if you could clarify why you joined the immigration restriction lawsuit and what that does, when the ACLU is already involved, what difference does it make that you join the file? Maybe take the
Okay, well, the first issue is one of the things that's alleged in our complaint is that Time Warner, Spectrum Time Warner, was actually using the slowness of its own network, which we know were created by its own failure to upgrade its systems, and going to content providers like Netflix and others and saying, you're not getting through to your customers fast enough, pay us extra to go to get faster service. So they were using their own misconduct to sort of essentially try to get more money, at which the service was actually originally free to content providers. The net neutrality rule stopped that from happening, but you're quite correct that there is a danger that if the net neutrality rule goes out, conduct like that might start again. Now, the fact that we've shined a spotlight on this makes it, I think, unlikely they're going to do it in this instance, but that is an example of some of the problems that could emerge if, in fact, they repeal net neutrality.
And on the issue of joining the lawsuit, what does that practically do when the ACLU is already
Okay.
involved?
So just to make sure everyone understands what we're talking about here, this has to do with something completely different. This has to do with Trump's executive order restricting immigration that was issued late on Friday, and we have immediately offered to assist any of the lawyers seeking to represent detainees. 17 attorneys general, 16 colleagues and myself put out a very strong statement that we view the executive order as unconstitutional, that it would ultimately be struck down by the courts, but that in the meantime we were committed to trying to protect people who are essentially caught in the crossfire not just by the executive order, but by the way it was rolled out, with no planning, no notice to the people on the ground, no consultation with the people at DHS and state. So our first goal was to try and make sure no one was being improperly detained at New York airports. I immediately wrote to DHS, got a very prompt response and an assurance that they had consulted with the U.S. Attorney's Office in New York and were not violating the court order. 4 separate courts heard various complaints in 4 separate federal district courts around the country, and every one of those courts found some likelihood of a constitutional infirmity in this executive order and ordered some form of stay or another. Now, in addition, so that's the situation now. What we have out there is chaos because people are continuing to arrive. The orders to the people on the ground at the airports are unclear. The policy has changed over the last few days, and they've reversed themselves on several matters. We are joining the lawsuit, and as you'll see in our complaint, it's going to be, I think I can fairly say it's a pretty fleshed out complaint as compared to some of the other pleadings that have been filed. Is really based on the fact that in addition to harm to individual detainees, this does harm to New York and really all the people of New York. We're a city and a state that depend on immigrants. We are institutions of higher learning, our medical institutions, the finance community, the tech community, and there are New Yorkers who live here who are not detainees, but who are also hurt by the executive order, who may have family members overseas. So there are a lot of rights that are implicated other than the rights of the specific detainees. The lawyers who've come in have sought to certify a class just on behalf of people being detained. And keep in mind also that the detainees that we're dealing with right now are only under one section of the executive order. There are other sections shutting down the refugee program permanently for Syrians, and taking other steps that we view as constitutionally impermissible. So we're intervening because there are separate damages done to the state of New York and to all the people of the state of New York by this executive order.
In terms of the president's Supreme Court nomination, do you have any impressions on this judge, and how do you think the Senate Democrats should handle this?
My impression is that there seems to be an effort to portray him as similar to Justice Scalia 2.0, and to make an argument that somehow Justice Scalia was in the mainstream of American jurisprudence. And I strongly reject that assertion, and I would call your attention to 2 Scalia opinions, Heller v. District of Columbia and Oger-Berfel v. Hodges. And Heller v. District of Columbia was an opinion which Scalia sought to rewrite 100 years of precedent and jurisprudence on the Second Amendment, radical rewriting of constitutional law. And in Oger-Berfel, which was the marriage equality decision, it took a position that I think was completely at odds with our understanding of equal justice under law, and it's something that people in the LGBT community should be very concerned about. If this judge is saying, I'll be like Antonin Scalia, I think we got a lot to worry about. And I think the Senate Democrats should give him a full hearing. I think we should insist on 60 votes, and let's clarify for the American people what they are portraying as the mainstream. I think this is an effort to rewrite history and portray a radical justice who sought to break with precedent and rewrite constitutional law as a part of the mainstream. I strongly disagree with that assertion.
What was the Heller D.C.?
The D.C. v. Heller case was a case where, for the first time in American jurisprudence, no court had ever struck down a reasonable limitation placed by a local government on the sale of guns. Bans on machine guns were upheld, and all courts had always interpreted the Second Amendment as having to do with the clause in that amendment that refers to a militia. Heller read that clause out of the Second Amendment and said there's an individual right to bear arms, and struck down the District of Columbia's own effort to regulate gun possession, and it essentially disrespected a century of prior holdings of the Supreme Court interpreting the Second Amendment.
Two-part question, but the two parts are related. You have been investigating Exxon and climate science and their research in that area. Based on what you've learned so far, does Rex Tillerson, who's a former leader at Exxon, deserve confirmation by the Senate as Secretary of State? And also, can you just update us on the status of your investigation, of your probe into Exxon?
The Exxon case is ongoing. We've received many documents from Exxon. We have appeared in court in New York County Supreme Court on several occasions, and a judge has taken jurisdiction over our subpoena. Maura Healey, the Massachusetts Attorney General, has also issued a subpoena, and a Massachusetts court has taken jurisdiction over her subpoena. At the same time, while Exxon is claiming they're submitting to the jurisdiction of the New York and Massachusetts courts, they've gone in something that I think is unprecedented in the history of American jurisprudence into another court in Texas to try and seek an injunction against two state law enforcement officers simply investigating whether or not there were violation of state laws. So that matter is ongoing. They are making document production, so the investigation is ongoing, but we are litigating in 3 separate courts over this.
And based on what you've learned, does Rex Tillerson deserve confirmation? Would he be a good Secretary of State?
I would not vote for him.
Just identify your name.
Okay, Stephanie Pagonis, New York Post. Do you have any comment regarding the termination of Acting Attorney General Sally Yates?
I mean, I've worked with Sally Yates. I can't say I know her very well, but I have worked with her in her capacity as Deputy Attorney General. She's a first-rate lawyer and highly professional. Trump said she betrayed the Department of Justice. In my mind, she stood up for the department when Trump betrayed the Constitution.
Any other questions? Think so.
Thank you.